Good morning, everyone, and welcome to this session. Today's webinar topic is in relation to avoiding common employment law mistakes and workplace disputes. This is a topic that remains consistently relevant and costly across all sectors. In Kenya, termination-related disputes continue to dominate matters before the Employment and Labour Relations Court. In many cases, employers are surprised by the outcome, not because the decision to terminate was necessarily wrong, but because of that the process followed was legally effective. Time and time again, we see situations where a relatively manageable workplace issue escalates into protracted litigation with significant financial exposure and reputational risk. What is striking from a lot of this litigation is that these disputes often don't arise from complex or novel legal questions. They stem from basic process issues, such as inadequate documentation, failure to follow due process, poorly handled disciplinary hearings, or misunderstandings about redundancy, performance management, and the like. In other instances, employers have acted decisively but overlooked the procedural safeguards provided by the Employment Act and well-established court jurisprudence. So today's session will focus on common process pitfalls that arise in the employment life cycle. Njeri will take us through recruitment and end us off with redundancy. Daniel will take us through the disciplinary process, and then Desmond will also deal with discussion on performance management of senior employees and exits. We will thereafter have a short Q&A session, so please place your questions in the Q&A box. With that, I'll hand over to Njeri to get us started.
Hi, everyone, and lovely to see you here this morning. Thank you for joining us for this important discussion. The first thing I would say on recruitment is that the Employment Act does actually set out what is required from an employment contract perspective and what makes a valid employment contract under Kenyan law. Those are set out in Article Section 9 and Section 10 of the Employment Act. And they are the following. So you need to have the employee's details, a name, age, address, sex, etc., the job description, the commencement date and the contract type and the duration, the place of work and the working hours, remuneration, benefits and intervals of payment, continuous employment period, so how long they'll be employed for, leave entitlements, sick pay, pension, maternity or paternity, and adoptive leave and collective agreements on overseas assignment details. So on all of those specifics that are set out in the Employment Act, we now look at where the common employment mistakes lie. So the first one is a reliance on an employment contract or an offer letter that then does not translate into an actual employment contract. And we see that a lot where an offer letter has been used and relied on by the employer. And when it comes to termination, there's actually a no valid employment contract that the employee has been relying on. This can lead to obviously the litigation risk. We know very well that Kenya is very employment friendly, and therefore it is very important for employers to be aware that a valid contract containing all of the provisions that are set out in the Employment Act has to be the first principle and the first principle applied. Yeah. The second thing is a lack of a clear job description. That lack of clear job description, which must be set out in the employment contract, leads to a litigation risk because when you're looking to terminate the employee, you're not clear as to what the grounds of the termination could be, if it is a performance-based issue or if it's an issue related to what the role of the employee is in the company. That definitely is one of the issues that can come up because you have not set out how they have then non-performed or how they have not met what the job description was. And therefore, that is a clear litigation risk. The practical guidance on that is to make sure that when you're advertising the role and when you're putting into the employment contract, the job description is very clear so that everyone is on notice as to what the expectations are and therefore what the termination provisions could be in a case of a termination of the employee for poor performance. The next one that we can say is on on the recruitment and when you're taking on an employee or when you're making an offer, there could be assurances as to promotion, bonuses, remuneration, how those remunerations are calculated. And then when it comes to the employment contract, or if you're relying on an offer letter, that then does not carry through to the document. And so it must be clear from your employment contract how remuneration will be done, how the bonus structure is, if there is one, what the KPIs or any milestones that must be met before promotion can be obtained, so that the employee is clear as to what the expectations are. I think a general running theme for this is that any employee looking to make a claim against an employer will rely on the fact that there was not enough clarity, or they were not sure of certain provisions in their employment contract. If the employment contract is therefore found lacking, there could be a claim there. So ensuring that the employment contract, first of all, is clear, and second of all, the records are kept. So, for example, if you're doing appraisals, or if you're doing assessments, and how those assessments have been made, then how the promotion has been obtained or not obtained, how the bonus has been calculated or not, or what the measurable performance indicator is for that, so that everyone is clear on what the expectation is. Again, the litigation risk is a claim against the employer for that. Yeah. Other key legal risks are in terms of the probation period. Under Kenyan law, you can have a 6 months probation period, up to a 6 months probation period by the employer, and a 6 months extension, but only with the approval of the employee. So it's 12 months in total, but 6 months of those have to be approved by the employee. If that is not set out clearly in the employment contract, or if the probation is there for a longer period than is that is prescribed by law, or if the employee does not have an opportunity to comment on the probation period in the latter 6 months, if an extension is required, that is also a breach of the Employment Act, and therefore something that the employee can claim. So being clear on probation and what it means, and how it can be calculated is also a litigation risk. Again, if you're terminating someone on probation, the notice period for that is 7 days. And some people just terminate immediately. That is not possible. It has to be a 7-day notice period to give the opportunity for the employee to wrap up. Being clear on that and how that is done within the company, there may be an issue for the handbook, maybe an issue for your employment handbook, but certainly in the employment contract, the probation period needs to be set out, and needs to be set out clearly as to how it will be extended if necessary. So all of that to say that the practical guidance is to understand the Employment Act. Obviously, refer to us as lawyers who can advise you on whether the employment contract is valid. Make sure that you're giving the relevant period. So if it's a fixed term, indefinite period of our contract, understand what your obligations are to the employee. Clarity being the first one, so that everyone is on the same page at the relevant time. I think I'll end there, and I'll be happy to take questions on the employment contract at the end.
Thank you. Then we'll hand over to Daniel.
Yes, good morning, everyone. Thank you very much for joining us. My focus today is on issues that come up repeatedly before the ELRC court in Kenya, the common mistakes employers make in disciplinary and termination processes, and how those mistakes turn manageable cases into expensive legal disputes. The central point I want you to leave you with is that most employers do not lose in court because they had no valid reason to terminate the employee. They lose because they handled the process maybe in a messy way. In an employment dispute, the onus is not to prove that the employee was wrong, but that the employer did everything right. Under Kenyan law, particularly sections 41, 43, and 45 of the Employment Act, an employer generally has to prove two things. So maybe we could go to the next slide. Yes, so the first limb is that the employer has to show the reason for termination was valid and fair. Second is that the process was fair. I could also add maybe a third, which could be a fair outcome. Courts are keen on what they term as a band of reasonable response, which is a legal test used to determine whether an employer's decision in dismissal falls within the range of actions called the band of reasonable responses. So if any one of these limbs fail, the termination becomes unfair and unlawful. Most employers know this, yet we continue to witness employees getting huge awards in the Employment and Labor Relations Court. So today I want to talk about some common mistakes employers are making and what employers should do differently. The first mistake happens long before the disciplinary hearing. As Jerry has elaborated, it starts at recruitment and onboarding, where many disputes become difficult to defend because the employer's documents are weak from the beginning. Go to the next slide. Next one. Yeah, so we often see no proper written contracts, outdated templates, unclear job descriptions, inconsistent terms, no disciplinary policies or grievance policies, no performance management frameworks, no sexual harassment policies where one is required. And even if policies exist, they were never issued, explained, or acknowledged by the employee. So when a dispute later arises over performance or misconduct or termination procedure, the employer has no reliable paper trail. So a court will then ask what are the terms of engagement, what rules ought to have been applied, and what standards is the employee expected to meet. So if the employer cannot answer that clearly, then the case becomes harder to defend. So what employers should do is treat recruitment documents and internal policies as part of litigation prevention. That means should issue clear written contracts, ensure that job descriptions are specific and current, align contracts with practice, update handbooks and policies, and circulate them to the employees properly. One important thing is also to obtain signed acknowledgement from employees of these documents. One thing I need to mention is that in a recent case also, Shuki versus KPLC, the court cautioned against casualization of labor, which is that it was termed as an unfair labor practice. This is where some employers keep renewing short contracts for years and assume that each contract has an expiry date that they can simply stop renewing without risk. That is dangerous because Section 37 prohibits casualization of labor. So where conduct repeated renewals and assurances or create a legitimate expectation of renewal, the employer may still face a claim. Therefore, employers should audit all their fixed term contracts and ask, why is this role fixed term? Is there a genuine project or funding cycle or season? Or have we created an expectation of continuity? And are the renewal communications carefully managed and documented? The second common mistake is terminating on suspicion or proof, rumors, office gossip, and things like that. So in practice, this often sounds like we have lost confidence in that person, or she was clearly involved in that situation. This person is not working out. Those are not enough. Section 43 requires employers to prove the reason for termination. Section 45 requires that the reason be valid and fair. So the employer must show that what it believed, why it believed it, and what evidence it relied on at the time. So a common example is where money goes missing and management immediately blames an employee who was on the shift, but there is no witness evidence, there is no reconciliation, there is no access record. So the case becomes very difficult to defend. Employers should insist on having an evidence file. That means you define the allegation clearly, gather relevant documents, interview the right people, preserve all the evidence, and document why the employer generally believed that reason for termination existed. So if it is not documented on the file, it will not exist in court. The third mistake is that employers only invoke lawyers after the damage has already been done. By the time a lawyer is called in or legal, the employer may have already issued maybe a defective notice to show cause, held a flawed hearing, or used the wrong legal ground. And so legal import is often something that is seen to be for the litigation phase, but in reality, it is very important and valuable at the risk stage before the process already collapses. So the focus should not be on the cost, but on the value that this brings. This is especially true in cases involving senior exits, which Desmond will speak further about, fraud allegations, or whistleblowing, mutual separation negotiations. So employers should escalate early and seek legal guidance early and not late, because we are here to help you, and this is a very sensitive process which you should not be able to do alone, where the case may be sensitive, or there are protected right issues. So the earlier legal is involved, the cheaper the problem usually is. The other fourth mistake is probably the most common litigation trigger is failing to conduct a real disciplinary hearing. So Section 41 requires the employer, before terminating on grounds of misconduct, poor performance, or incapacity, to explain to the employee in a language they understand and allow them to be accompanied by another employee or shop union representative and hear and consider their response. The courts have even pronounced themselves that an employee should be allowed to even bring a lawyer in some instances where no prejudice will be suffered by the employer. But what happens in practice is normally not a hearing, it's a conclusion disguised as a meeting. So for example, an employee is told to come in that we have concluded an investigation and the management has decided to terminate you. Do you have anything to say? So that is not a hearing. That is probably just a notification. So employers must ensure that the process includes a proper notice to show cause, which has to have clear allegations of the charge, not generalizations. So using the words like gross misconduct or insubordination or words that are vague, it's better to be very specific about the clear charge that is being put to the employee and the contract violations that they're accused of. Then they should also be invited for a hearing, and this invitation should include rights that the employee should be aware of, the right to be accompanied. They should be told the venue. They should be told, they should be given reasonable time to prepare their defense. They should be supplied with the material that is going to be relied on. And also for hearings, employers should make sure that the disciplinary panel is properly constituted. And so this means that the accuser should not be the interviewer and also the executioner. So there should be clear roles where the process seems fair. Minutes should be properly minuted and signed. And in the minutes, you should also indicate the deliberations, the answers given by the employee and the deliberations made after the hearing. So this hearing should be a real one where the employee has a real chance to influence the outcome. So if the answer if you ask yourself, can the employee influence this decision through this hearing is no, then that process is most likely unsafe. Mistake number 5 is a fair hearing is not merely the right to sit in a room and speak. It's the right to know the case against you and prepare for it. These are the rules of natural justice, the rules of fair hearing. And because many employers make a mistake of inviting employees to hearings but do not give them the evidence beforehand, probably they do reports or documents or witness materials that are never shared with the employee and probably sometimes are just placed before them on the day of the hearing. That is considered an ambush and not due process. So the employers should ensure that the hearing invites include the exact allegations, the supporting documents, the possible outcomes, the date, time, and venue, as we had said. So the employee should never be blindsided because it will not be seen as fair. Another mistake is treating poor performance like a misconduct. Poor performance and misconduct are not the same thing. During terminations, poor performance usually requires a different process where you have to have clear KPIs and evaluation criteria, communication of those expectations to the employee. There has to be an evaluation and an appraisal. The employer must show training and support to the employee, and also a structured review process and a fair opportunity to improve. So employers should not jump straight from your numbers are low and your employment is terminated. So they should ensure performance cases have a proper performance management record, and because poor performance must be managed before it is terminated. Another mistake, which is a very common problem, is when HR or do not push back when maybe a management just wants someone out. So HR may know that the process is weak but does not push back. This is where exposure grows, because once the outcome is predetermined, the procedure becomes artificial. So HR must see themselves not just as an administrative function, but a risk control function. And they should challenge predetermination, insist on evidence, document objections where necessary, advise management where the process is legally unsafe. So HR teams are not there to rubber stamp unlawful decisions, but are there to protect organizations from them. Another major weakness is a lack of internal capability. Sometimes the issue is not the law or the policies. The issue is that the people running the processes do not know how to do it well. So we see, poorly drafted show cause letters, bad investigations, incomplete minutes, inappropriate suspension decisions, inconsistent outcomes between different employees, and line managers who make, damaging statements during these processes. And therefore, HR employers should do is train the HR teams, train line managers, train investigators and decision makers in investigation, in minute taking, in evidence preservation, in drafting these notices, in handling disciplinary hearings, and even when they are called upon to testify in court, they should be trained on how to become a good witness. And it's important that documents should be signed also where appropriate, as we said before, because even where these meetings happen, we find employers often lose because the documents are poor. And typical gaps would include unsigned contracts, unsigned warning letters, unsigned hearing minutes, missing attendance records. There's no proof of service. And when the case gets to court, then the employer has a hard time to show a clear story. So the HR or the employer should maintain a complete process file containing all documents and appropriately signed. As I conclude, there is also another important commercial mistake employers do, and sometimes the employer has a defensible concern about an employee, but the process was already mishandled. So maybe there was no proper hearing, there was poor documentation, there was, and at that point, the employer may still decide to litigate, maybe out of principle, but that can be costly because the weakness is procedural and already difficult to cure, and the courts can award very huge sums. So in some of these cases, the sensible decision is to explore an early negotiated exit or settlement rather than, spending months or years defending a weak case. They should know when to escalate. Employers should know when to escalate a case commercially, not just procedurally. So not every case should also, be fought. Some should be settled early and intelligently. The last mistake, maybe I would highlight, the list is not exhaustive, is forgetting the basics at exit. This is finally, even when the employer had a fair reason and a fair process, they sometimes create fresh claims at exit. This includes, withholding of terminal dues, unpaid leave, pure communication on notice, delayed payments, No certificate of service. Section 51 of the Employment Act requires that an employer should issue a certificate of service, and just disorganized offboarding. So this creates avoidable claims, and therefore employers should have a proper exit checklist, covering salary for up to last day worked, and leave reconciliation, notice or pay in lieu of notice. Statutory deductions should be proper, and and certificate of service. So before any disciplinary termination, finally, an employer should ask itself, one, so we could go to the next slide. One is the contract and policy framework in order? Number two, what exactly is the allegation or reason? What evidence supports it? Has there been a fair investigation? Do we need legal input now rather than later? Has the employee been issued with a notice to show cause and been given the evidence? Has the employee been invited to a disciplinary hearing and been informed of the right to be accompanied? Has there been a real hearing under Section 41? Is the outcome proportionate and consistent? And has a termination letter been issued and the employee given a right to appeal? Is the file properly documented and signed where necessary? Is the process strong enough to defend, or should settlement be considered? And are the final dues and exit documents ready? Where performance is involved, you can ask 3 more questions. Were expectations clear? Was support given? Was the performance improvement plan, properly measured and documented? And the employee should always be given, the court should always see that there was an intention to improve performance, or there was an intention to consider the representations made by an employee during a disciplinary hearing. So my closing thought is this: most disputes are, not first lost in court. They are lost much earlier, and courts will not ask if the employee was wrong, but did the employer do everything right? Thank you very much.
Thank you, Daniel. Hand over to Desmond.
Sorry, thanks, Jen. So I'll be taking through the managing of exits of C-suite employees. Please confirm you can see my slide.
We can.
You can. Okay, great. Great. Yes. So in just talking through the managing of exit of C-suite employees, the first thing that we'll be looking at is just maybe if I can just give an overview. So we'll have a brief introduction as to who these C-suite executives are, and what their roles are, and then we'll look at the common reasons for their exits, the common mistakes. We'll look at the role of mutual separation agreements, court considerations when enforcing such mutual separation agreements, and proactive strategies, other proactive strategies that an employer may use when handling exits. So in terms of the C-suite executive, so these are employees who, this is your chief executive officer, your CFO, your CIO. And in some cases, some of these officers have a dual role. So they are both employees performing an executive role, and they are also sit as directors in the company. So when they perform such dual roles, the obligations for both roles are distinct, and the process of termination for those roles is also distinct. So it is important to be alive that both processes have to be undertaken, and to be alive as to which process to undertake. So when terminating employees and the C-suite employees under the Employment Act, so as a senior executives, they're entitled to the normal protections under the Employment Act, that means that you have to terminate them on a substantive reason, and you have to follow the due process. Whereas in terminating them as directors of the company, you have to follow the procedures under the Companies Act. So so it is important to be alive as to the obligations arising under the two processes. Now, I'll briefly cover the common reasons for exits of C-suite employees. So the challenge normally comes about when terminating the senior executives. The challenge comes about because, unlike the junior employees, for the senior executives, a common reason that usually arises is because the board has lost confidence, in the executive. For instance, like the CEO, and because of that loss of confidence or trust in his leadership, they would want to part ways. Another common reason is, probably, for instance, a change in strategic direction, and the board feels like somebody else is better suited to drive the new direction of the company, and not this particular executive. So these, if you look at the Employment Act, for instance, the requirement of having a substantive reason now does not provide or does not include loss of confidence as a standalone reason, a valid reason for termination. So you find that it becomes a tricky position for the employer or for the board in this instance on how to go about it, because often when there's now the loss of confidence, in most cases it's a mixture of both performance and misconduct, and identifying what these areas are sometimes can prove tricky. So examples are, for instance, personality clashes or power struggles at the board, soft performance issues like a negative attitude, and so forth. So what should an employer do then in such a situation? So in such a situation where, the lines seem blurred between performance and misconduct, the responsibility of the employer is to drill down to a reason, that can be justifiable before the law. So if it's a performance-related reason, records of previous evaluations now become very useful. So, they're looking at now, for instance, if you have a 360-degree evaluation whereby the C-suite executive, has also been evaluated by the people that he's supervising, and there's feedback as to his management style, and that is considered as part of his appraisal. So that when there are complaints about, for instance, harassment or just poor leadership, there is something that can be relied on. Rather than trying to gather the evidence, for purely for purposes of dismissal. If you have a record of evaluations, then it becomes easier to bring that subject for consideration as a possible reason for termination of the senior executive. If it's a case of misconduct, for instance, probably a case of fraud or such other misconduct, it's important to conduct your investigations, maybe with the assistance of an external independent investigator who would look into the conduct of the executive, and who would gather the necessary evidence and conduct the necessary interviews. So when that is documented, at least then the board has evidence on which it can rely on as purposes of having a cause-based termination. So so once you have maybe before I go to mutual separation. So once you have identified the specific reason, the substantive reason for termination, then you can undergo through the normal process. If it is an issue of misconduct, then you can go through the normal process of termination, as already outlined by Daniel, which is the notice to show cause and so forth. Now, there are many instances whereby, because the person is a senior executive, the employers feel that they do not want to go into the route of the normal termination, and they would prefer to separate with the senior executive through a mutual separation agreements. So yes, mutual separation agreements can be used, but it depends on the timing, when and how you use them is what is key, so as to mitigate the risk of the employee suing the company for unfair termination. So, and some of the key considerations of a mutual separation agreements is, the terms that need to be considered is the separation date. So an agreement as to, when the separation date is. There has to be a discussion of the ex gratia package. There has to be provision for independent legal consultation, so that the employee is informed that they have the option to consult independent legal advice. And in some jurisdictions, we find that employers are even giving the executive a stipend to pay for legal advice. And then the mutual separation agreement should also have provisions on confidentiality and non-disparagement clauses. And this really is to help manage the narrative of, manage the narrative for the exit. So that the employer has control as to what narrative it wants to release as to why the employee left the organization. In many cases, you would find that both the employer and the employee in this instance will agree and will have a draft statement, that they will agree, which they will agree upon, that will be released to the public as to the reason why the employee has left. And then there's the mutual release from all claims, so whereby the employee now covenants not to sue the company for any, to sue the company for unfair termination in the future. Then it may have some post-termination restrictive covenants, for instance, a non-compete, non-solicitation, a non-solicitation clause. So, in terms of when to use a mutual separation agreement, in practice, what we have seen, it's usually useful to introduce it when you already have done you've gathered your evidence for the reason of separation. So, for instance, if it is misconduct, you have already done your independent investigation, and you have gathered the evidence, and you are ready to proceed on a formal process of termination. The mistake that we see is that employers, introduce discussions for mutual separation prior to gathering this evidence. And then when the employee declines to accept the mutual separation, now when they try to go back now and gather the evidence, the time between which the evidence is gathered and when they begin the formal process of termination has taken too long, and therefore the employee can argue that this is just a premeditated decision. You are working backwards. You are working backwards to justify my exit. So timing is everything, and if possible, it's usually best even to issue the show cause letter first before you begin discussions on a mutual separation. So you issue the show cause letter for purposes of inviting the employee to give their side of the story, and then once they give their side of the story, if it is not sufficient, then now you may have without prejudice discussions for a mutual separation at that juncture. So timing is everything. In the case of poor performance, you'll have records already of their previous evaluations, and feedback. So it's not like you are now going to start discussions of a mutual separation before you have records of their poor performance, because when you try and gather that, when you try and do that evaluation post discussion of a mutual separation, then the evaluation will be considered a sham. So those are key things to consider. So for the mutual separation agreement to hold, there's the evidentiary elements. There are key considerations that need to be considered so that it can be a binding contract. One is voluntary, so you must give the employee enough time to consider the mutual separation proposal. So, for instance, giving somebody like 2 or 3 hours, a few hours to consider and come back may be considered as coercion. So, give them a couple of days to consider the proposal, and even alert them that they have the right to seek independent legal advice. And then document your discussions on the mutual separation, so that there is clarity, and to avoid situations whereby, if, for instance, the mutual separation does not pan out, there are allegations as to what was promised and a rebuttal by the employer. So just document to make sure that there is clarity in that respect. Yes, and then other ways that you can manage exit of C-suite employees is this can be done at the contractual stage. So like what Njeri had covered in terms of recruitment, for senior executives, especially for the CEO, it's important, or it's wise to have short-term contracts, and not too short that they do not have a reasonable period within which to execute the vision of the company, but it should also allow for non-renewal in the event that the board loses confidence and they feel like probably they want somebody else. So for instance, you can have a 3-year contract whereby now the senior executive is allowed to execute their functions, but and if they do not perform as required, then the contract can be they can just simply let it expire by a fraction of time. So short-term contracts is one proactive way of managing exits of senior executives. So the other thing is in the in the mutual separation agreement, as a proactive strategy also is to make sure that you give the benefit that you give, the monetary benefit is more than the statutory requirements. So for instance, more than your accrued leave, more than the notice period, so that it can be defensible if later on the mutual separation is challenged. It can be defensible in the sense to show that if the employee took an enhanced package, then there was consideration for that agreement, and it will be easier for the employer to show that it was voluntarily accepted. But if it is the bare minimum, as bare minimum statutory benefits, then the court is less inclined to enforce that mutual separation agreement. So thank you. So I think the takeaway for this is that for managing exits, especially using mutual separation agreements, context, facts, and timing is important, so that you can mitigate the risks of a fallout between the employer and the employee. Thanks. I'll hand over back to Jean.
Thanks, Desmond. I think Njeri is going to then close us out by dealing with redundancies. Over to you, Njeri.
Hi, everyone again. I think in the process of discussing termination and how employees are exited from their employment, redundancy is one of those issues where people think, or most employers think, that it can be done, first of all, very quickly, and second of all, that there isn't actually a set out process in the Companies Act. We're dealing with a client at the moment who has not followed procedure, and the employees who were made redundant have taken them to court. And so this is something that all employers should be extremely aware about. There is a set process and there's a way to do it. So to start off with, a redundancy is not a redundancy of a specific employee. It is not a way of getting rid of the annoying accountant or the person that is causing trouble in the office, because the redundancy deals with the termination of the role, and not of the person. It is the role that is no longer required and not the person. And in that, when you're thinking about, I've got 5 accountants and I want to streamline the business to 3, the reason for doing that is an economic reason and aligned with your business plan. So start with the position that we're restructuring our business and we're considering how best to deal with all of the employees within that business. And the business plan needs to be the working document that you can evidence as the reason why the redundancy needs to take place. In some companies, it will not necessarily be a business plan. It could be a decision of the board. It could be a decision of the management. But there needs to be evidence that you have considered why a redundancy exercise needs to take place and the reasons for that. That is important because the employees can then take the employer to court if there's no set out reason. Then the start of the redundancy is actually that all of the employees affected, all of the employees in the titles that are going to be affected need to be notified at the same time. So it is not a case that you can notify a specific accountant or a specific secretary or PA or whatever. It has to be all of that job function that are notified the redundancy exercise is taking place in respect of them. So all of the 5 accountants must be given the same redundancy notice. And at the same time, that notice has to be given to the labor officer where your office is. That step ensures that you have, first of all, notified the labor officer, and you've notified the employee of the start of the redundancy exercise. So once you do that, you're telling them that your job is on the line because of the business plan that we have. Therefore, we'll be taking you through the redundancy exercise. That kicks off a 1-month notice period. And the 1-month notice period is for you to consider which of those 5 accountants can I get rid of? And a lot of people miss out that 1 month period and think that they can just do a redundancy straight away. The 1 month period has to be given 30 days to consider the employees and see whether there's another option for them. Can this accountant be migrated to another role? What skills does this particular accountant have that can be merged within the role? Who is best suited to take up the new role or the new function that has been created? And therefore, it is important for you to consider that in the 1 month period, and consult with the employees to give them assurances during the 1 month as to what criteria is being applied. There is the criteria of last in, first out. Yeah, which means that if, for example, you have 5 accountants, one of them came, in the month of January, the redundancy is taking place in March, you can decide that the criteria applied is that the person who came last is no longer required, and that is also applicable. You can also consider if the person that you're making redundant is still on probation, for example, or whether they're serving some kind of notice period, in which case that can also be a criteria that is applied. So looking at it within the 30 days will enable, and consulting with the employees will enable the employer to better understand what criteria can be applied and who the redundancy applies to. So that 30 days has to take place. After that, the other pitfalls that we see is that employers do not, at the end of the 30 days, notify the employee of the decision and notify successful employees who have not been made redundant at the same time that their job, that they're staying in employment and their job is no longer on the line, or the decision. So everyone has to be given the decision, not just the affected employees. And then the labor officer has to be informed at the same time. Out of the 5 accountants, we decided to keep 3, and 2 of them have been made redundant. So a letter must be sent to the labor officer at the same time as a letter is sent to the employees. Within the termination on account of redundancy, then we see a lot of miscalculation of the dues. Yeah. The first one is that you're entitled to a severance pay of 15 days for every year served. That is a statutory amount that must be paid to an employee being made redundant. So if you worked for 2 years, you're entitled to 30 days pay. If you've worked for 3 years, etc. Yeah, and then you're entitled to your leave entitlement, which includes any leave that you've accrued for the period. And then you're entitled to your notice period. If the notice says 3 months, yeah, you can either decide to pay out the employee the 3 months notice, or they can actually work the 3 months and only be made redundant at the end of the notice period. So that is a calculation that you must make as an employer as to whether you would like to pay out the notice, or whether they can work the notice period even if they've been made redundant. And so they're terminated only at the end of that notice period. And then obviously you can do as a separate gratuity. Yeah, if you do a gratuity entitlement, note that you will be setting a precedent, and that other employees who are made redundant will be expecting as the same or more of a package, because you do not want to treat employees unfairly. And then obviously the salary for the month worked. So a lot of the pitfalls that we see is employers paying the wrong amounts, terminating the employee ahead of time, before the redundancy exercise has actually taken place, not notifying the labor officer, and then treating employees preferentially during the redundancy exercise. So those are the things that we would say must be avoided in order to ensure that the redundancy takes place well. Yeah. There is, guidance from the courts on whether, and cases that we can rely on that have found 4 employees where during the redundancy period there was no meaningful engagement with the employee as to the redundancy and how it would be carried out. That has been found to be a breach of the Employment Act. So non-consultation is a breach. The not indicating the 1 month period has also been found a breach of the Employment Act, and that has related to payments. So, all of these things must be weighed very carefully. We would advise that you do a step plan at the beginning of the redundancy exercise, once you know that you want to undertake it, so that you can have meaningful dialogue and meaningful steps and dates to indicate when is the letter going out to the employees, who are the employees affected, when are we notifying the labor officer, when are we then terminating them, will they serve the notice period. Note also that it is very different where there's a trade union involved. Much more complicated for companies where a trade union is involved, because you not only have to notify the trade union, but the collective bargaining agreement may have separate provisions dealing with redundancy and payment on redundancy that have already been pre-negotiated. And so on the trade union matter, consult with the relevant representatives, as well as the collective bargaining agreement and the employees themselves, and follow that procedure. I think I can end there and take any questions as well.
Thanks, Anjeri, for that. That was very insightful. There's been some questions in the Q&A chat box. Maybe, Anjeri, because you're still on screen, before I move to Daniel and Desmond. One of the questions asked was in relation to notification to the Labour Office and how practically you go about doing that. If you can just take us through very quickly.
So first of all, you need to decide on which Labour office it is. It's per county, and depending on where your office is located. And it's not, unfortunately, it's not a science, but you need to check and Google where is my Labour office. And normally we do a hand delivery of the letter. You get an acknowledgement of that letter. Please note that in relation to any employment process and any documentation that is being provided either to the employee or to the labor officer or anyone in the process, it is important for you to have an acknowledged copy, not just a copy, but an acknowledged copy by the employee or by the relevant labor officer to evidence the fact that it was delivered, and that can be used in court as well.
Thank you. To you, Desmond, one of the questions raised was in relation to mutual separation agreements and whether an employee can actually lawfully waive their statutory rights.
Yes, that's a good question. So according to Section 26 of the Employment Act, it's not possible to waive the minimum statutory benefits of an employee. You can't contract outside the statute. You can contract above the minimum, but you can't exclude the minimum. So, for instance, say, enter an agreement to say that you've agreed that he will not be entitled to his accrued leave. It will not. That agreement will not be enforceable.
Thanks, and I guess it speaks to your point about making sure that the package is actually enhanced, so that if it's challenged, at least you have that.
Yes, absolutely.
Daniel, on your end, one of the questions was in relation to management of exits, but now for the issue of physical incapacity. And maybe very briefly, you can just take us through that and how that would differ, I guess, from what you'd already highlighted.
Thank you, Jane, and thank you, I believe it's Phoebe, for the question. So for, termination in cases of medical incapacity, the court has given guidelines on how that should be, undertaken. So one is employers should ensure that they have, a proper medical assessment, and therefore they have to support the employee first in terms of recovery. And the law calls this, giving reasonable accommodation to the employee. So the employer should ensure that they afford the employee, let's say, the sick leaves that are provided by statutes, but that is just a floor, it's not a ceiling. So the other structures which the employer can use to support the employee, this could be through assistive devices or through work arrangements that are remote work or something. So the employer has to show that they have made reasonable accommodations to this employee. Now, if it reaches a point where now the assessment shows that there will be no longer or for the foreseeable future, this employee will not be able to perform, then this assessment should be done independently. Then a notice should be issued to the employee that the employer is considering termination on grounds of incapacity, and should follow the same procedure of issuing the notice to show cause and doing a Section 41 hearing on those grounds before termination.
Thank you, Daniel, and thank you, everyone. I'm looking at the time, and unfortunately, we've run out of it. It was lovely to have all of us here to have this discussion, which was very insightful. We are available to take more detailed questions offline, and the relevant presentations will be shared with the attendees of this webinar. Thank you, everyone, and we look forward to seeing you at the next webinar in a month or so.
Bye, everyone.